crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome into the attorneys. Thank you so much for being with us tonight. Another interesting topic of conversation. Got an excellent panel to lead the way, but a couple of ground rules you're going to want to make note of. First of all, to join our conversation, you'll see across the bottom of the screen all evening tonight, there are ways that you can get in touch with us. We'd love to hear from you. The show is much better the more you are involved in it. Also, Hollis Wright does something pretty unique. I'm going to bring Josh Wright in for this because Josh, he's managing partner of Hollis Wright. But also, you guys make attorneys available while the show is on the air tonight. Why do you do that?
Well, it's just our way to give back to the community. It's almost a public service, if you will, and we've been doing it for about 10 years where, you know, if you've got a legal question and most people are intimidated to contact a lawyer, you want an opportunity to contact a lawyer for free on an issue that is impacting your life or even potentially something that amounts to a case, we're here to be able to help. And, you know, we've been doing it for 10 years, but
right.
If you call, text, email, you're going to get a live lawyer on Sunday night.
So take advantage of that free, all fair, confidential conversation. Introduce the fella just to your right.
Well, personal friend John Lewis, who's been a friend of our firm's and just a friend of mine for many, many years. And although we don't always cross paths, we're always able to pick up with one another as soon as we do see each other. So first of all, welcome. Glad you're on the show.
Thank you, and thanks for having me.
Absolutely. So, you know, David, one of the interesting things about this topic, which is alternative dispute resolution in the legal world known as ADR, that's our acronym, is that, you know, roughly 90% of the cases that John and I file and others file across the state are resolved before they get to trial. And, you know, I do think that there is an increase in the number of cases being tried today, post-COVID, than there were before.
Okay.
And I think the number will increase and the percentages of trials will increase. But right now, we're still doing the vast majority of these claims are resolving one way or the other, and a lot of times it's through the mediation or the alternative dispute resolution process, and John is right in the middle of that. And so we thought it would be good to bring somebody who is a mediator and kind of is involved in the ADR component to be able to answer questions about how cases get resolved, why we would avoid a trial, how you can get closure through settlement, et cetera. So, you know, John, we're super excited to have you on. This is a great topic. It's super fitting for the type of work that we do at our law firm, and the number of times we use mediators, as you well know, is a lot. How did you get into this area? Because not every lawyer does what you're doing, and it's unique to have someone that does that. So how did you get into alternative dispute resolution and kind of mediation?
Right, well, I've been practicing, as you know, for almost 30 years. And my partner and I decided that it would be interesting if we got involved in the process of mediation. We've litigated cases for years, but as you said, most of them settle. So I really enjoy bringing people together. I think I have a good way of talking to our clients over all these years. And so Danny and I just discussed it, and we thought that that would be a good area to get into and to help people resolve their disputes.
Talk a little bit about the mediation process, because there's so much confusion. When I prepare a client for the mediation process, they think initially, oh my gosh, like, you know, this is binding. Whatever I say is going to be held against me. It doesn't work that way.
No.
Explain a little bit just generally about mediation and how it works.
Okay. A lot of people think meditation.
Yeah, that's right. It's definitely not that either.
It's not.
It can get intense.
But, you know, it is good to meditate about it. And what I mean by that is to plan for the mediation. I think a lot of people come into mediation without a structure, a strategy, or plan. But the process works by everybody getting together. And that doesn't necessarily mean in the same room. Sometimes it does mean in the same room. But everything that's said in mediation is confidential and cannot be used at trial. And the reason for that is so that we can be candid, we can be open, and we can discuss the issues so that we can discuss a resolution. So it's very confidential. The mediator is a facilitator. The mediator goes to each party and tries to talk about the case and see how the mediator can bring the parties together. And so the mediator is not making a decision and not going to decide your case. You can tell the mediator you don't want to settle the case, you want to go to trial, and that will be the end of the mediation.
Yeah. You can tell a calming voice.
He's got it.
He's got it, right? So that's what, a lot of times, that's what successful mediators have, is the ability to, and there are fireworks at times at mediation, as you well know, and I know you see it from the parties, and people want to win their day in mediation. The reality is you want to have someone that's calm, composed, and can maintain a good temperament to create an environment where people can evaluate both the strengths and also the weaknesses of their case to see whether or not resolution is possible.
It's something that we're certainly seeing in this day and age, probably more so than ever, is folks flying off the handle and responding with just full of emotion. Mm-hmm. And that's never the best way to make a decision whenever you're all keyed up and you've got so much in it you can't see the other side. Isn't that a part of what a mediator, a good mediator anyway, brings to the table?
It is helping to, number one, empathize with the parties and understand what the party's going through. And if you can do that, that's kind of what parties want. They want to be heard. And I think that gets back to what Josh was saying and why sometimes parties come into the mediation thinking this mediator is going to decide my case. It is somewhat of a process, so it gives that party a sense of being heard. And a lot of times that's what the party wants. So if the mediator can listen, let the party vent those emotions, and then things can calm down a little bit and they can get more into the issues at hand.
And I know with our mediations, a lot of times we will do presentations, whether it's PowerPoint or through some other format. A mediation in some senses can also be kind of not a mini trial, but a mini exposure of what the plaintiff believes the claim will show in front of the jury, and the defendant has the ability to respond during that process in a confidential format. But ultimately what you do is you take that information, don't take a side, and then try and structure the opportunity to consider meaningful settlement conversations. Right. Isn't that ultimately the goal?
That's exactly right. The mediator is a neutral. We call ourselves neutrals. So we're not going to be on this side and we're not going to be on that side. We're just going to talk through the issues, ask a lot of questions, and try to get the parties to think about their case in relation to how it might end up if it goes to a judge or a jury. And so that is the role of the mediator, is to not take sides and to try to get the parties to see their own case and the risks that are involved.
John, what are the ways generally that a case can get to mediation? I know it's not just when the court gets involved. I mean, how generally do you find that mediations get set up?
Well, very rarely do the parties themselves go straight to mediation. Usually an attorney is involved, although it can be that way where they don't have an attorney. Anybody could find a mediator and mediate their case. But typically, either the attorneys get involved or an attorney, an adjuster, if it's a personal injury type case, they can get involved and decide that they want to mediate the case. Sometimes the courts order mediation. So it varies among all the different cases.
When we come back, because I know we're getting ready to go to break, David, when we come back, I want to talk about the potential for finality in your case if you go to mediation, and whether or not you're always going to get finality. Sometimes you don't. And so we'll talk a little bit about that, and we'll hit John up with some of those questions.
That sounds good. Before we head to break, just a reminder, you're going to want to follow Hollis Wright on social media. So Facebook, Twitter, Instagram, wherever you are, they are also a great YouTube channel as well. Just search Hollis Wright and you'll find them all over social media, especially whichever one you prefer. We're stepping aside. We'll be right back. More of the attorneys after this quick break.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the attorneys. Appreciate you being with us tonight, talking all about mediation. These guys, like lawyers do, have a fancy phrase for that I'm not even going to attempt. But we appreciate you being with us. If you want to join the conversation, attorneys are standing by right now. What do you call alternative dispute
resolution? ADR, my friend.
Why can't
ADR.
you attorneys just use?
Well, you know what, we like acronyms. We like phrases like that.
ADR.
That's it.
I'm going to go with ADR.
That's
a question we've got here about whether a particular case can go to mediation. Are there cases, maybe ground rules as to what can go to mediation and what cannot be resolved that way?
You know, David, not really. And before I get there, I will say some people refer to it as appropriate dispute resolution.
Appropriate.
There you go.
But any case can pretty much be mediated. They even have a program at the Center for Dispute Resolution, which is the organization at the state that kind of oversees ADR. But it's a foreclosure program. There's a family promise program for people who don't have a lot of money who can do domestic mediations for divorce. It depends on your income level. Consumer disputes can be mediated. Commercial disputes can be mediated. I've even heard of criminal cases being mediated with regard to sentencing and so forth. So pretty much any case, if the parties agree or if a judge orders, can be attempted to be mediated.
You've got to be trained to be a mediator, do you not? Talk a little bit about that and why that's important.
You know, in reality, you don't have to be trained. In order to be registered with the state in the Center for Dispute Resolution, you do have to have 20 hours of training. If you want to do domestic mediation, you have to have 40 hours of training. And if you want to do domestic violence mediation, you have to have another 10 hours of training. But anybody can go out and mediate. They just can't be ordered by the court to mediate because you have to be registered. And it's interesting, a lot of people talk about certified mediators, but in Alabama they're registered, they're not certified.
Gotcha. Talk a little bit about finality and whether a mediation is final. I know a lot of times the unknown of what a jury's going to do, any lawyer that tells you, you know, they're going to win 100% of the time, is just not doing their client justice, because anything can happen in front of a jury, right? You got certain lawyers who are probably better than other lawyers insofar as it relates to trying cases in court and probably have a better track record than others. However, the reality is juries can do different things based on who's on your jury panel. Talk a little bit about the finality of mediation and how that plays into taking that out of the hands of the jury.
Yeah, you know, as you know, Josh, an attorney who tells you they've never lost a case has probably never tried a case, because you don't know what the jury's going to do. And in this day and age, with the different Generation Z, millennials, you know, Gen X, baby boomers, there's a lot of different dynamics that go into the jury. So when you mediate, you have a sense of control over your case. And the parties can kind of come together and decide. No case gets mediated unless both parties agree. So, but you don't have to agree. And you can take that gamble and go to, you know, it could be a judge or a jury, and you can go to that judge and jury and give them the evidence, and there's going to be a winner or a loser at the jury or judge stage. But at the mediation stage, you're going to decide your fate.
So you have the ability to settle the case if you desire to at mediation, but if you don't desire, because you don't think what's offered is appropriate, you don't have to settle and you can plow forward towards trial.
Exactly. Many times a party may come with no real intent to settle. Yeah. And if that's the case, obviously the other side's not going to agree. And in that event, you're going to say, well, I'm sorry, we can't get it done. Let's go forward.
You know what, as I listen to this, and this is more of a public policy kind of thought here, but why are not all cases tried mediated first before they go to trial? Because I would think the expense of getting a couple of attorneys and a couple of clients and a mediator together versus a courtroom and a judge and a jury and the cost and the expense, and I mean, that just seems so much more practical. Yeah. Why is this not done more?
That's a great question, David. And some jurisdictions do, out of state, do require mediation before they go to trial.
Jurisdictions in Alabama do?
No, jurisdictions out of state. Okay. I'm not aware of one in Alabama that does require that.
Maybe in practice they do, but not mandatory.
Right. And so I agree with you wholeheartedly. I heard about a case recently where it was a commercial dispute. One party was at $400,000, one party was at $250,000. They couldn't close the gap. It ended up going to a verdict in over $2 million, and the experts and the attorneys, and they could have gotten it done, for $400,000. So I agree with you.
Way too practical.
What is one of the questions people will have is, like, how long does this process take? Is it a multi-day process? Is it a one-day process? How does it normally work with you?
Typically, it's a day-long process, I would say. You start around 9, you usually bring in lunch, and you end between 3 and 5. That's your typical mediation. But there's half-day mediations. Yeah. I've had a mediation that took 2 hours. And there's some mediations that go into the night, 7, 8. Some people feel like you should not break the momentum. Some people think you should take a break and come back the next day or next week to give people a sense of calm.
Let's assume something doesn't settle at the mediation and someone's 2 months out from trial. You actually stay involved with the parties to still try and facilitate resolution in that 2-month period, don't you?
Absolutely. Unless a party tells me, I don't need you to call me anymore, we're not going to settle this case. I'm not going to keep bugging them, obviously, if they do that. But if they're going forward to trial and they're not telling me to stop, I'm going to keep calling periodically, not every day, and I'm going to try to see if we can work towards resolution.
You know, David, one of the things that's interesting about a mediator, and John gets used in this capacity too, sometimes the mediator is a way to reopen and rekindle conversations without having, as a party, to look weak to be the one to reinitiate that, and you can use your mediator to do that. It doesn't happen all the time, but sometimes it does. Sometimes it's just the mediator contacting both parties to try and figure out whether or not there's additional conversation that needs to take place. But sometimes you can actually use your mediator to your advantage, not to show a level of weakness, to get back to the table to discuss issues. Because who knows what happens? Let's assume you have a mediation, it breaks down, then you take 3 depositions, which are important getting prepared for trial. Well, those depositions don't always go 100% your way, right? And so now the value of your case has to be reassessed. As a good lawyer, that's what you do. You reevaluate the case, and sometimes you may get your own mediator back involved to be able to say, hey, look, we need to rekindle conversations. I know we're getting ready to go to break. When we come back, I want to talk about some of the other ADRs that are out there, arbitration, hired judge, those types of things. We'll just talk about that.
All right, we're stepping aside, our final break of the evening. We'll be right back after this short break.
I'm attorney Carter Clay with Hollis, Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. Just right about 6 minutes remaining in the show. If you want to take advantage of the opportunity to speak with attorneys who are standing by live from Hollis Wright, you got about 6 minutes left to do so. Josh?
All right, so one of the other categories of dispute resolution that I know you have familiarity with is arbitration. Can you just kind of generally describe how arbitration works in relationship to what a normal jury trial would be?
Sure. Typically it's done by agreement or in contracts, but both parties hire an arbitrator. It can be through the American Arbitration Association, and the arbitrator is paid by both sides typically. Sometimes it's only by the commercial side if it's a consumer transaction. And the arbitrator acts as the judge. There's discovery, there are deadlines, and then there's a hearing that typically takes place in a conference room, but it could take place in the court if you had space in the courthouse. But the arbitrator actually makes the ruling and decides the case.
And that most of these arbitrations are binding, are they not?
They are binding, and it's very, very difficult to appeal an arbitrator's ruling. And even if the arbitrator doesn't necessarily follow the law.
And do you find that those are most often found based on consumer contracts, like purchasing a car or purchasing something like that, or by agreement of all parties to arbitrate?
I do. I mean, it's never really ordered by the court unless it's in an agreement and someone's moving the court to order it. But yes, it's usually between a consumer transaction, although there are a lot of big commercial transactions that have arbitration agreements in their agreements.
David, arbitration is, the reason it kind of was invented was to streamline and shorten the litigation process. And make it more efficient for businesses. I think there's some positives to it. Be careful what you ask for. Sometimes you can get a really nice arbitration verdict. We've gotten several. But generally, lawyers shy away from arbitrations when they have the ability to go in front of juries. So it just kind of depends. This really has been an evolving concept over the last 15 years. Sometimes it has been appreciated by plaintiff lawyers, sometimes it has not been appreciated.
Isn't this the kind of controversial practice of sometimes arbitration is snuck into a contract and you cannot take it to trial because you agreed for it to be arbitrated? Is that similar to what we're talking about?
Yeah, that was the concern at the beginning of what arbitration really was, and it was fought a lot by plaintiff lawyers. However, over the years, some plaintiff lawyers using the arbitration process have gotten some gigantic verdicts. And then all of a sudden, some of these arbitration provisions got pulled out of contracts because the businesses said, well, hold on, I have a more conservative jurisdiction with a more conservative jury than maybe the arbitrator that I'm going to get. And so it really has gone up and down over the years. I think right now it's generally accepted as it is a mechanism by which you can resolve a case that sometimes you've got to navigate through depending on certain contracts.
You agree, John?
I do agree, and also there's another industry, FINRA, which is the Financial Industry Regulatory Agency, of which I'm an arbitrator. Every case involving brokers or the financial transactions such as securities has to go before FINRA and be arbitrated.
The one drawback, of course, is it is more efficient. Sometimes it's faster. Sometimes it's streamlined discovery. One drawback is you do not have the ability to try your case in front of a jury. And if you've got a good trial lawyer that likes to try cases in front of a jury and kind of craves that environment because they feel like they can get larger verdicts, it takes away that ability. But as a lawyer, you got to roll with the punches that you're given. Sometimes the client comes to you and they're in an arbitration proceeding, and you got to figure out whether or not you can be successful in that environment or not, regardless.
It also limits the right of appeal if you lose.
That's right.
Believe it or not, we're out of time. We've got just 2 minutes remaining in the show. I want to give both of you the opportunity for a final word. And John, if you would, you go first, please, sir.
Yeah, I think mediation is a really good concept. It's been around for about 30, 40 years, but it's still in its initial stages, and I think more and more people can help themselves by accessing mediation and trying to resolve their case with using their control.
Yeah, and I think that's right. And I hear mediators say all the time, and John said it today, which is, David, that there are unknowns when you try your case in front of a jury, and that is a fact. Sometimes you get that one juror in your jury panel who's going to be tougher to convince of a theory than another juror. Mediation gives you an opportunity to take it out of the hands of the jury oftentimes and resolve a dispute and have some level of finality. The other thing is jury trials take time to get to, and even though you may think, for example, you're set for a jury trial next February, there may be 15 ahead of you in the system, in the queue, and you get pushed until next June. So it's a streamlined process to resolve cases. My theory with mediations always has been that, and it's done with respect, a mediator is not going to make me and my client settle a case if we don't want to. However, we're going to use the mediation process to evaluate whether settlement is appropriate given the facts and circumstances of the case. And I think there's a reason why you use mediation to your advantage to do that. So first of all, thank you, John, for being on. You did a great job, and ultimately you've covered a great topic that I think is very important.
I appreciate it.
Appreciate both of you all being on with us, and as always, we really appreciate you joining us each and every Sunday night. I want to thank you for being here tonight, and we hope to see you next week. And we hope that you all have a great week. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.